supplementary list. Progress filing item 2, WPS 6680 of 2023.
WPN number 6680 of 2023. Council, you are the respondent.
Well,
Yes.
Yes, Connection 3 is the award. The terms of reference is Connection 3 at page number 25.
Records required or not required?
I think records
After
were-
hearing it, I will not adjourn the case for records. Tell us.
I think the records are.
WPL number 6680 of 2023. Counsel for the parties are present. Counsel for the petitioners are accept. Records be called for from the concerned court. Office is directed to call for the records from the court of presiding officer, Central Government Industrial Tribunal, come Labour Court number 1, Dhanbad. In reference case number 17 of 2017, decided by award dated 28/9/2020. Let this order be communicated to the concerned court for concerned tribunal for compliance. Yes, yes. बिना डेट के यहाँ कोई केस नहीं होगा. बिना डेट के केस मतलब होता है बिना सरनेम के आदमी. ऐसा नहीं होता है. Every case has to have a date. Tell us when you want. 12th November.
yes,
Post this case on 12th November for final disposal. Your father was a son-in-law.
so for the petitioner is
Take care. Petitioner's father was a son-in-law who had taken compassionate appointment in the name of son.
That is not the issue, that has not been also called for.
Take care.
Yes,
I'm just indicating.
yes, yes.
Item 3, WPL 3328 of 2024.
Tribunal is not non-functional.
Yesterday we have filed an IA also. They have issued a prohibitory order, and in the IA
No, we are not concerned. You say that the tribunal is non-functional and therefore
in fact the
the court
website,
is not non-functional.
the court, in fact the judge, the presiding officer in Asansol was in charge of Dhanbad.
Yes.
The website today shows that even Asansol is vacant, even he has superannuated, so even he cannot decide. The judge in charge has also demitted office at Asansol. Asansol is also vacant.
You are from
Dhanbad is-
Union of India?
For same employee provident fund organization.
This is the website screenshot of CGIT today's.
Dhanbad. What is this?
Dhanbad is showing that the PO Asansol is the judge in charge, and Asansol is also showing who's who, that it is vacant now.
You call Mr. Anil Kumar. अभी 4 दिन पहले order. And on the day when this case was filed, right, on 17/5, the court was not vacant.
It was not
Then
vacant.
why have you moved this court here?
Because the judge, we have mentioned in the writ petition that the judge in charge is only coming 1 or 2 days in
Where
the.
have you mentioned?
Lordship, it is not regular hearing,
Where
has not
is-
been, it has not
where
even
is it
been
mentioned?
admitted, Lordship.
Where is it mentioned?
In the writ petition, para 12, that is coming for 1 or 2 days, selectively 4 or 5 cases are only being heard. It is not possible for him to hear all the cases. Para 12, the office of the presiding officer, Central Government Industrial Tribunal number 2 at Dhanbad is vacant since November 2023. The office of the learned presiding officer, Central Government
As per the provisions of employees provident funds, is there any provision for pre-deposit?
that is only for section 7A under when 7A proceeding under section 7O of the Act.
That's it.
7O says that if there
This
is
is
a
14B.
14B, there is no provision.
This is 14B.
This is 14B 7Q.
There is no question of any pre-deposit.
There is no question of
When you are seeking interim protection, what is your prima facie case?
the primary ground is that the notice that was issued, primarily there was a proceeding earlier for the period 2016-19, but thereafter they issued a notice not only covering 16 to 19 but 20 onwards also, 2020 to 2023, for which we had no sufficient notice. Moreover, Lordship, although not mentioned in the memo of appeal clearly, in the memo of appeal that has been filed there, but the additional ground, Lordship, there is a circular which has been issued by the CPFC because 2020 to 23 also covers the COVID period, and during COVID period there was a relaxation even for section 14B for the period of lockdown, and that has also not been
That has been
considered.
waived?
That has not been
waived,
considered.
or that has been waived or only deferred?
That
I'm
that
sorry,
it says
it
that
cannot be
in
waived.
no, it is not waived.
It is only deferred.
No, it says that due to administrative difficulties, there may be the 14B is attracted not only in cases of non-deposit but also in cases when there is deposit after delay.
That's right.
The money has to be deposited by 15th of every month.
That's right.
Now, during the COVID period, during the lockdown period, if there has been delayed for say 12 days, that is the chart which is annexed at page 43. If there is delay of 10 days also, then also the penalty is attracted. The circular COVID period, Supreme Court also gave relief that during lockdown period, it was not possible administratively to ensure to that strict timelines, and therefore, for at least for that period, some consideration was to be given, and this circular was also issued by the CPFC saying that for if there is some delay, that can be considered. There is no consideration straight away for the entire period, including the COVID period. They have imposed the maximum penalty of 100%, and that is the order under
So
challenge.
this is for COVID period.
For the COVID period, we
And
are
what
in
about
appeal.
the rest?
For the rest,
You are in appeal only for the COVID period.
no, for the rest period, if there is delay, but that has not been considered, and that is the ground. So far as mens rea ground is concerned, which is taken in the appeal, that after horticultural may not survive. Now, mens rea is not a ground for a selling an order under 14B after the decision 2022 Supreme Court McLeod. But even otherwise, even if mens rea is not a valid consideration now for completely waiving
What was
penalty.
your ground for not submitting the amount? For not depositing?
See, the COVID period
You
relaxation.
forget about COVID period.
Yes.
Remaining?
Remaining the period has to be examined. The other
No,
ground
what
taken.
examined? What was your
the-
ground for non-deposit?
The non-deposit. No, it was not a case of non-deposit. It was a case of
Delayed
delayed
deposit. Yes. What was the ground of your delayed deposit?
The ground for delay in deposit was that this case first of all relates to the contractor's employees. They were not the direct employees of TVNL, which is a government company. It is operating a thermal power station at Lalpania in Bokaro
They
district.
have been declared to be your employees by any.
No, they have not been
application?
declared, but the EPF says that the liability is on both. They have, our case was even in the 7A proceeding that they have left out the contractors, they have straight away fastened the liability upon the employer.
No,
So-
I just want to know, under the provisions of EPF, the principal employer is equally liable?
The principal employer is equally liable. The principal employer is liable, there is no dispute, but leaving aside the contractors and fastening
They
the
were necessary
liability.
party. They were necessary.
They were
parties.
necessary parties, and therefore, when the liability was disputed for 2016 to 19 only, for 16 to 19 there was also a 7A proceeding. Now for 20 onwards, they have clubbed the whole part and issued a common order. In fact, the order says it is only 20 onwards. The order may be seen. It says only 20 onwards, whereas the notice is for the period prior also. The order is at page 55.
You call Mr. Anil. ASG.
So far as I know, the central government has already issued an advertisement for appointment of presiding officers in various tribunals.
Recently, we have passed certain order also, wherein we have observed that if the Asansol authority is in charge, that doesn't mean that he will do nothing. In appropriate cases, and when the parties are ready, then he has to adjudicate. आप थे ना?
Yes, Mr. Somashekhar was added.
हाँ, वो अपलोड हो गया ऑर्डर. आप थे ना? कहाँ है ऑर्डर?
WPL number 2016 of 2020.
So WPL 2016, wherein I have observed that officiating does not mean that you are just there to give dates. Because this is a regular feature of all the industrial companies.
This was passed just 10 days back.
Yes, you got the copy? Nikali copy, nikali updated on uploaded.
In this case, so far as this case is concerned, Union of India is not a.
What is the present status? They have recovered.
They have issued a prohibitory order. Yesterday, I have filed an IA. They have sent a prohibitory order to the State Bank of India saying that you freeze the account, stop all operations, and make out a demand draft. It may not have been in the
What
file.
is that IA?
It was filed yesterday. This is IA number 11328.
11328 of
2024.
It cannot be rendered remediless. The tribunal is non-functional. Now, till the tribunal becomes functional, either by way of a regular appointment or by way of officiating arrangement, you can't proceed like this. They have a right to obtain an order of stay, isn't it? Their stay petition is also pending before that point. So you stay your hand, we'll stay the operation of the order.
So far as this case is concerned, counter has already been filed.
No, we are not going to decide the case on merits. The prayer is very limited. That the authority is non-functional, the court is vacant, no further arrangement has been made. So they are seeking only stay of recovery, and I've heard them some, at least they have a case to some extent that you did not make the contractors as party. They were the best ones to actually say what happened, whether. And one more thing, Mr. Bakshi, I just want to know from you. Suppose a person does not make payment of wages at all. Still, they are liable to pay.
On accrual basis, they have issued orders, but
No, I just not
Yes.
not in. Suppose the employer says that I have not made any payment of wages. Then also there is a deemed wage payment.
No, there is no deemed wage payment. There is no direct provision in the act or in the scheme.
Yes. That is unless there is payment, there is no question
There
of
cannot be
benefit.
deduction.
There cannot be deduction.
There cannot be.
Ideally, I think so.
Yes.
And in all the cases, there is employer and employee's contribution both.
Both. But there is a provision that if the employer has not deducted and subsequently if it cannot be recovered from the employee, then the employer is liable, because in the first instance the employer has to deposit both and then recover.
That's right. So therefore, in a case where the computation is done, there is a computation of employer's liability and then the employee's deduction, both.
Both.
Employer and employee's contribution, both are to be clubbed together and deposited.
Yes.
Therefore, under normal circumstances where wages are being paid, deduction is being made, and if there is a delay in deposit, then under any circumstances, there cannot be any liability less than 50%.
No,
Right?
there are two ways of imposing liability. In fact, There are two
At least
provisions.
for
7Q is for interest, which is for the loss due to the delay. 14B says that because the money is invested and the corpus suffers, therefore additionally there is a penal liability, penal damages liability. They call it damages, the damage caused to the corpus of the EPF fund, which is administered by the trust, the Central Board of Trustees. For that they additionally impose penal damages. But for the delay, that can be taken care of by section 7Q, which provides for interest 12%.
This
From
is
the
from
date of
Ranchi.
Yes.
लिखिए सर यूनियन ऑफ इंडिया को बुलाइए हाँ एसजी
He's on late period. 3.
The petitioner is only concerned with the prohibitory order because it is a generation company. If its bank account is frozen and attached, then it cannot make payments. It has to make various payments for transportation, etc. of coal. It will affect the generation of power.
लिखिए WPL number 3328 of 2024 with IA number 1138328 of 2024. This writ petition has been filed for the following relief. The learned counsel for the आपके वो आसनसोल वाले CGIT. He has also resigned.
Yes, ma'am.
Now this is vacant.
Recently
Completely?
it is vacant. Somebody has been nominated, but I have been informed.
You see, this is a case.
The advertisement has already been issued.
So that we have already recorded. It
Yes.
will take 6 months time. You have stated so, right? On affidavit you have stated. So somebody must have been made in charge.
I verified, but at the moment I cannot say. Madam.
Can you please let us know? Because now we have a case. They are seeking stay by saying that the court is non-functional.
Let the matter come up tomorrow. I'll inform.
Can it be done by
Today I have some difficulty continuously in court number 1. I have matters. I have some. Therefore, let the matter come up tomorrow. I'll inform.
Okay.
Tomorrow.
Should we make you a party, Union of India?
No, I'll inform.
Not required.
No,
Just
it's not
information
required.
should be
I'll
sufficient.
inform Lord so far as that part is concerned. If your lordship makes a party, then I'll have to seek
Yes,
instruction
yes.
and all
I
those
just,
things.
I,
But
you
I'll
just,
inform
you
lordship.
just seek us, tell us, right? Because we have to,
Yes, something
report.
needs to be done. Well, some alternative arrangement must have been done. Well, therefore, I'm saying.
WPL number 3328 of 2024 with IA number लिखिए ना. उसके बाद this petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner has challenged the
But may I take you?
yes, sure. The petitioner has challenged the order passed by the tribunal. No.
No, we have not. The tribunal has not passed the demand notice has been issued during the pendency of the appeal.
No, I just want to know.
Yes.
The final order was passed by the tribunal.
No, the final order was passed by the EPF authority. At page
And then
20.
you did not file appeal against that?
No, we have filed the appeal. The appeal is pending.
Appeal is pending
Before the
CGI.
CGI number.
When does the matter pass to the tribunal?
After the order under section 14B levying penal damages has been passed by the EPF authority.
See, we find that after the authorities who pass the order under section 7A or 14B, the matters are challenged before the tribunal.
Yes, so we challenged, order was passed,
Appellate tribunal.
the EPF appellate tribunal.
Yes.
So the order, the EPF appellate tribunal, the order of the EPF authority is challenged,
Yes.
14B.
Yes.
So here a 14B order was passed at page 55.
Yes.
That order has been
Passed on 14/12/2023, page number 50.
23 by the Assistant Provident Fund Commissioner Bokaru.
Yes.
That was
Against this, the EPF tribunal is there.
EPF Tribunal is the CGIT number 2.
Okay.
So there we find EPFA 8 of 2024, page 58. In the
This
central
is the appellate tribunal.
This is the appellate tribunal. There the case is still pending. On merits it has to
Yes,
be
yes.
adjudicated.
The learned counsel for the petitioner submits that the order passed under section 7Q and 14B of Employees Provident Fund and Miscellaneous Provisions Act 1952 has been challenged before the appellate tribunal. But the appellate tribunal is vacant and no alternative arrangements have been made. He submits that the authority at the appellate, the presiding officer of the appellate tribunal at Asansol was given the additional charge at CGIT number 2 at Dhanbad, but he has also discontinued, and therefore the petitioner has no remedy. He has submitted that a stay petition has also been filed. The learned counsel has also submitted that the substantial period involved in this case falls within COVID-19 period. He has submitted that a prohibitory order has been issued by the respondent authorities dated 18/10/2024 to the branch manager, State Bank of India, Lalpania branch, asking the state authority to remit the entire amount of rupees 25,39,191. He submits that the prohibitory order may be stayed and appropriate order may be passed. He submits that the petitioner is engaged in generation and distribution.
Yes.
Generation and distribution of electricity supplies. The
My submission would be that order had been passed in year 2023. Appeal was preferred in month of April. Since till now petitioner had not taken any step, and now it is not functioning. This interlocutory application has been filed.
The learned counsel appearing on behalf of the respondents has submitted that the order impugned before the appellate tribunal was passed on 14/12/2023 and appeal was filed in 2024, in the month of April 2024, and the writ petition was filed on 17/5/2024. And at that point of time, the authority at Asansol was in charge of the tribunal, and therefore the petitioner is not entitled for any relief. In response, the counsel for the petitioner has referred to the statement made in paragraph number 12 of the writ petition to submit that the presiding officer, Central Government Industrial Tribunal at Asansol, was in charge and was holding the court for 1 or 2 days in a month. And at that point of time, he was in charge only till 30th of May 2024. He submits that being the in charge court, he was not holding the court regularly and therefore the present petition has been filed. And as on today, the petitioner is completely limitless.
We had also filed a stay application also over there. Annexure one by one.
After hearing the learned counsel of the parties, considering the aforesaid facts and circumstances, this court has called upon the learned Additional Solicitor General of India, who has appeared before this court and has assured this court to inform tomorrow as to whether any alternative arrangement has been made considering the aforesaid facts and circumstances and the emergent situation which is arising pursuant to the prohibitory order annexed to the interlocutory application. And considering the fact that the petitioner has been rendered remediless as on today, this court hereby stays the operation, implementation and execution of the order in view of the
Page 7 of the IE.
सिर्फ उससे नहीं होगा ना, फिर दूसरी जगह prohibitory order करेंगे
हाँ वो भी
इसीलिए वो जो एडजुडिकेशन है उसका बताइए डिटेल्स.
that is
Page
uh,
55.
that is at page 55.
Execution of the order dated 110 order number 1105 dated 14/12/2023 passed by Assistant Provident Fund Commissioner District Bokaro and also the prohibitory order dated 8/10/2024 annexed with the interlocutory application. Post this case tomorrow, awaiting instructions through Mr. Anil Kumar, learned ASGI Senior Advocate, so that appropriate order can be released. Final order कल करेंगे, आज आपका कर देंगे.
Only if today's order could be given
It will be. I understand. Remedy कर देंगे तो बचेगा ही क्या?
वो भी
हम
है,
इसका order
and the greater concern is that all operations have stopped.
We'll do it just. आप जाइए, आप अभी जाएंगे ना इसको और टाइप करके यहीं पे दे देंगे हम करेक्शन. You have recorded it.
Deeply.
Tomorrow we will pass an order that till he takes up the matter, if there is any alternative arrangement. Otherwise, we'll just make an observation that till the alternative arrangements are.
We are even willing to deposit. We are a government company. We are not running away. We are even willing to make a deposit. But the attachment affects the entire functioning. We have to make so many payments. Otherwise, it will affect the generation of power in the state, electricity.
You see, it will remain operative only to the extent of 25 lakhs and
Yes.
nothing more.
That also they don't do. They don't make it no debit up to 25 lakhs. They attach, they stop all operations in the bank account.
No, it is never like that. Prohibitory orders, they do not operate in that manner. Once the demand is satisfied, they have to release it.
From daily list act for final disposal item 2, Cholupil 6682 of 2023.
argue it.
Yes. The petitioner is aggrieved by the order dated 14/7/23 contained in Annexure 8 at page 104. Now this order is pursuant to your lordship's direction passed in
Page 108.
104 it starts,
100.
but this is preceded by your lordship's order,
Yes. Page 100.
page 100. So what had happened was there was an award passed by an industrial tribunal. The industrial tribunal's award gave certain directives. Directions were that, may I come straight to that award? Yes, ma'am. Kindly come to page 43, which is the part of the award which starts from page 39. 39 is Annexure 1, award passed in reference number 137 of 1991. The operative portion is paragraph 7. Now the question is whether the concerned persons were the genuine workmen of the erstwhile owner on the date of nationalization is definitely a question which requires a lot of investigations. In the term of reference, there is only the name of 397 persons. Their parentage has not been mentioned, nor there is mention of their age or the permanent home address. There is a lot of exercise is required to be done for the identification of genuine workmen to find out whether any of the persons mentioned in the list were the workmen of the erstwhile owner. For this purpose, Form B register of the erstwhile owner is required to be produced. The information regarding their being member of Provident Fund will also be required to be put into. But neither party has brought on record the documents. The concerned persons, however, have filed certain certificates from the erstwhile owners, which have marked Exhibit W1 to W5 series, to prove that they were workmen of erstwhile owner on the date of takeover of the aforesaid 5 collieries, coal mines. The genuineness of the certificates granted by the erstwhile owner is also to be verified vis-a-vis Form B register of erstwhile owners and the Provident Fund record, and also from the voter list of the locality of those collieries from the relevant year. Therefore, in such circumstances of this case, I think that there should be a screening committee to examine all these aspects of this case, in which there should be a representative of the sponsoring union and a nominee of the Regional Labour Commissioner Central of the concerned area to examine the genuineness of the concerned persons and also to find out if they were workmen on the role of the erstwhile owner of the respective collieries. Furthermore, the dispute regarding the employment is going on right from 28/5/74, and many of the concerned persons might have crossed the age limit of 60 years, and many of them might not be available for some reason or the other. Therefore, in that view of the matter also, a screening is required. Therefore, I formulate a formula for the screening of the concerned persons to find out whether any of them were the workmen of the erstwhile owner in any of the collieries mentioned in the reference order on the date of takeover or just before the date of takeover. These formulas will be as follows.
This is for identification.
I'll just.
Is it relevant? After
Yes, this
what
is
happened?
I'll just maybe half a page only.
Okay.
Yeah, yes, ma'am. All the concerned persons will submit a pro forma containing their names, parentage, age, permanent address, a recent photograph, and any proof in support of their being workmen in the erstwhile colliery, in the personnel department of the area of the colliery, through the sponsoring union within 60 days from the date of publication of the award. In no case, the period will be extended beyond 60 days. That is, if someone fails to file such format along with proof within 60 days through the sponsoring union, their cases will not be considered on any later date. So this is how the formula was done.
What did I do in it?
Then we'll come to your lordships. Then what they did, they submitted an application, and that was beyond 60 days. And that is why Your Lordship remitted the matter to the court, to the deputy, to the Assistant Labour Commissioner Central Dhanbad for consideration. So Your Lordship's order, paragraph 8, sorry, I'll start from paragraph 9, at page 102. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the award dated 29/8/2006, having strict timeline, was published on 7/10/2006. From the arguments of the parties, it appears that there is a dispute as to whether respondent number 2 had taken steps in terms of the award or not. And then the matter goes. The reasoned order thereafter follows.
So then everybody appeared, and then what happened?
And then the reasoned order says that there is a delay though, but this is a technical delay.
No, it is not a technical.
I'll point out that. Kindly come to 108.
This court did not extend the time.
No.
This court only said that it has to be verified whether the strict timeline has been followed or not.
Yes, and the requirements have been complied or not. So you're
Because
not
it will otherwise become never ending.
Yes.
Person may come anytime.
Yes. So you're not
Where is the
108.
finding? 108.
The last paragraph. Even if there may be treated some delay on technical ground in submission of application in pro forma by the union to the management, the delay is required to be. This is the finding which I am attacking.
Yes, respondent.
What is the 60 days? Now,
First tell us whether there was any delay according to you or there was no delay.
according to me, there is no delay. Only
Kindly
60 days-
substantiate.
That's
If there was no delay, the matter ends.
No matter ends.
Yes.
It is unnecessarily dragged.
No, therefore tell us
No,
that the
you are
award,
saying-
just a moment. When was
Award.
the award passed?
Award. Annexed to award is the award.
Date of award?
Yes. Date of award is 29 August 2006,
29/8/2006. Yes.
but it was published on September 2006. It was published. With the publication.
8/9/2006.
8/9/2006. Now 60 days has to be counted from the date of publication. That is the as per the award.
That's right.
Yes.
60
And
days expired
60
when?
days expired on 6. They have calculated at paragraph 19 of their own petition.
Yes, it is
Page
there.
25.
From 7, published on 7/10. You are saying?
7/10.
Yes. Later than that.
And from that 60 days it is 6/12/2006.
Yes.
That is their calculation.
Yes.
Now you Lordship may kindly turn to Annexure 6 of the writ petition. It starts from page 53.
53 is what?
Annexure 6 of the writ petition. Now it is dated 6/12/2006. The format is, then pro forma is given. It is a chart that is starts from page 55. List of workmen of so and so.
This is not the pro forma.
Yes.
This is not the pro forma. Where is the pro forma? You give a chart, the matter is same to same. On the basis of chart, how anybody can be identified?
Because
This
they
is
are-
not compliance of the order of the tribunal. Pro forma is accompanied with an affidavit. The matter, yes. This is not the compliance. You give the list, the name and everything. How does that matter? Each and every workman was supposed to fill up a pro forma. The union will not fill up the pro forma for them.
That is, that is every each and one workman has been given.
No, that
name-
is not
Name
sufficient.
and not particulars.
You see, the tribunal also observed that there are many persons who may not come. There are many persons who might have attained the age of superannuation. There could be many persons who are dead.
That can be.
No, there is no question of, there cannot be a roving inquiry like this. This is not compliance. We will not take this as compliance at all. This is the only compliance you have done.
Yes,
This is the chart.
So how is it delayed compliance? It is no compliance. Producing a chart is not the compliance of the order. Each and every person was required to be produced. He has to fill up a pro forma, give his details.
It is there under what they have understand they have done it. It is item.
Wrongly understood. If union will understand the cases in this manner, then only God can save the workmen. This order cannot be sustained. WPL number 668 of 2020.
And this, so far this filing of this on 6th December, it was also acknowledged by them. It is
I
not
will
that-
take care of that. Don't worry about it.
That is an extra.
the labor court, the assistant labor commissioner says it was received on 7th. So that is how it is 1 day delay. It is dated so and so, but served in our office on 7th. That is mentioned at the top of that letter, page 53, which my learned friend is referring to. Its receipt is dark number 2445, dated 7/12/60. Sorry, 7/10/2006. So that may be dated so and so, but then when it is served upon us, that is the date that has to be considered. That is how the assistant labor commissioner says that there is a delay, but technicalities cannot come in the way.
Now, so for next B of the counter affidavit.
This is sufficient compliance. Was it your case that it is not a compliance?
It is not a case of compliance.
I just want to know,
Sorry.
was it your case before the tribunal that it is not a
No,
compliance?
tribunal's award, we accepted it, but compliance has to be done by them.
That's right. No, this compliance.
Yes, it is
Do
not.
you say that it is not a compliance
It is
at
not
all?
a compliance at all. I have said so.
Where is it?
Paragraph 20 I have said so of the writ petition.
Yes.
That as the format was submitted beyond 60 days, the petitioner was not required to refer the same to the committee. In view of the strict time frame and the consequences mentioned in the award in the event of delay. Furthermore, even the format furnished was incomplete, inasmuch as the format did not contain age, present photograph, provident fund number, voter card, and proof in support of the fact
Yes,
that they were
which-
workmen of
What
the
do you want to say for counter affidavit? What is your response to this statement, para number 19? Have you stated anything with respect to para number 19?
Para 13. In answering this one, the union has submitted entire papers before the management within time, which is also admitted with petition by reference number so and so, which falsifies the claim of the petition. That is an step B.
Let us see annexure B.
Page 77. Letter of general manager controversial area. The reference to a letter dated so and so, that is answer 6, dated 6/12/2006 on the subject matter referring.
It is only the date mentioned. When was it filed? What is the date of filing?
That is 6/12.
Where do you say? Have you stated that it was filed on 7th? It was filed on 7th.
Yes, I have said so. That is the reason why the officer has given this finding. This was the reason why your lordship has remitted to
The
back.
delay of implementation of the award, that is 60 days.
Otherwise also your petition was not in terms of the order passed by the court. It was not in terms of the order passed by the court. Where have you stated when was it filed? Date of filing?
Yes.
On 7/12/2006,
7/12.
para 18.
Para 18. That is the only chart that they have said. And it does not contain anything, no photograph also. Bare minimum, except this chart, there is nothing.
You just see page 106.
6. Yes, middle paragraph.
Middle panel.
Yes.
The representative of the
Yes.
management. Read it please.
Submitted the same on 7/12/2016.
The representative of the management further stated that it is a fact that the sponsoring union submitted the pro forma of concerned persons on 7/12/2006, but long after the deadline specified in the award, that is 8/9/2006, hence the award is inoperative after lapse of 60 days. It was your case that pro forma was submitted?
No, what was submitted was this only. This is what was
Not,
submitted.
this is what your
Yes,
management
yes.
representative
That is how it
submitted.
has been written. But what was submitted is only this, nothing else. This they treat it as a pro forma or a table or a chart. Now let us see what does it contain. That table also.
Yes, respondent. Did you submit anything more apart from this?
This gives that what document I have submitted.
Yes.
You will also see at page 55. The list of Workmen of so many 5 queries, Pandavasur area with the home address, designation, date of appointment, etc. along with supporting documents, central government, etc. also with reference.
So this is the judgment. Right?
Now you will also see this page 55 top of annexure 6.
Yes, yes, I've seen that.
And you will also see date of appointment given, name of colliery, then appointment letter, voter list, chart.
Pro forma was to be submitted by whom?
That is
By the
what-
workmen.
Ah,
This is submitted by the union.
so many workmen.
So?
They are
Everybody
represented by
has
the-
an independent cause of action.
No, it is the case of the union. That's point number 3.
That's right. But were the workmen supposed to file the pro forma? Did the workmen file any pro forma?
No, individually they does not show, but this they represented before the union. They prepared all their names and all particulars and given in tabular form.
All the concerned persons will submit the
Yes,
proforma.
number one. That is the
That is
correct.
the first condition.
First condition.
WPL number 6682 of 2020. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that an award dated 29th of August 2006 in reference case number 137 of 1991 was passed by Central Government Industry Tribunal number 1 Dhanbad.
All the concerned persons will submit the proforma containing their names, qualities, so and so. To support of their being workmen in the erstwhile colliery in the personnel department of the area of the colliery through the sponsoring union within 16 days from the date of publication of the award. So it has to be filed by the sponsoring, through the sponsoring
Recent
union.
photograph did you file?
So that chart shows the human column along with these documents,
Which document?
along with supporting documents.
No. You see, Roman 1, all the concerned persons will submit a proforma containing their name, parentage, age, permanent address, a recent photograph, and a proof in support of their being the workmen of the erstwhile colliery in the personal department. Through the sponsoring union. Perfect. But sponsoring union has not submitted the proforma, it has submitted a chart.
They have given it to the union. They have prepared chart of the workman, this format, and given it to the authority of the colliery.
So,
It has to be individually. Each and every workman will go and file, submit a proforma.
no, through the union, but
Through
that
the-
proforma is to be submitted by the union after collecting it from them.
Definitely, after collecting, they have done it because it is not that individual sheet of proforma that they have filed. They are given by giving a tabular form according to their understanding. They have done it.
How many persons were involved?
397.
So all 397
Yes.
persons they came to you,
Yes, this is
and they have given you all the details,
Details.
right? In
Yes.
some of the cases, even those details are not there. You just see at a later portion. You see page number 94. From 353 onwards, even those details are not there.
that if they have not given any document or particulars which is required, then screening committee can reject their case by considering individual cases of the workman without taking into consideration, because award is not only one paragraph, that is one, rest paragraph are also there. The second part is the para 2, the management of this.
You just see, you at the top you say along with supporting documents. Where is that?
That they have not annexed.
At the top you mentioned along with supporting documents. Where are those supporting documents? Where are those supporting documents?
That has not been annexed to the.
You file it. You file it. You file the supporting documents. This was submitted before whom?
Before the- and this is what we have.
Personnel manager, personnel department of Pandaveshwar area Eastern Coalfield.
And they have stated that all these things were not submitted. Do you say that it was submitted along with that? It is absolutely unbelievable. Practically, I think it is, I do not know, wonders may happen, that all the 397 persons who were claiming employment since when? 1971, right, are there, all of them are alive, and all of them have approached you and have submitted all the documents. Therefore, it is very important.
2006 it was given.
Okay, you produce the documents. You produce the documents, all the supporting documents. You produce it, we will see what is to be done. 1 day's delay, we will see. You produce all the documents. Whatever was submitted. Likhiye, heard the learned counsel for the parties. The learned counsel for the petitioner has submitted that that pursuant to the award dated 29th of August 2006, passed in reference case number 137 of 1991. The respondent union had only submitted the list of the employees, list of the workmen, total 397 in number, who were claiming regularization.
No, yes, who were claiming that they are the employees of the
Who
erstwhile,
were claiming that they were the employees of
the erstwhile
ex-employee,
ex-colliery owner.
ex-colliery owner way back in the year 1971. He submits that although at the top of page 55, it has been stated that the chart was being submitted along with supporting documents, but no supporting documents, photographs, etc. were submitted. The learned counsel appearing on behalf of the respondent union has submitted that since it has been mentioned that it was filed along with supporting documents, he shall seek instructions and file the supporting documents before this court, which was filed along with the chart of each and every person. एक भी default नहीं होना चाहिए, सबको लेके आइए. We'll see what is to be done. The learned counsel for the petitioner is also directed to produce the records in connection with the documents submitted by the respondent union pursuant to their award. We will produce it. Should we call for it? No. Not required. Let them file it first.
Let them file first.
You file it first.
Let them file.
The affidavit of the union should clearly indicate as to whether these documents were filed along with the chart or not. False affidavit मत करिए. गलत affidavit मत करिए.
Towards here, the Lordship had passed an interim order on 3/7/24.
Opposed this case on 12th of November in the supplementary cause list. The affidavit should be filed by 11th of November. ज़्यादा टाइम का काम नहीं है, आपके पास तो सब होगा. ज़्यादा टाइम का काम नहीं है.
है नहीं था।
कौन नहीं है?
हम यहाँ पे रहेंगे, माफी मांगेंगे।
नहीं, इस ग्राउंड पे टाइम नहीं होगा. नहीं, हम आपको डॉक्यूमेंट, आप ऑल्टरनेटिव अरेंजमेंट करिए. इस ग्राउंड पे टाइम नहीं होगा. 397 persons who were employed prior to 90. You see it?
दो दिन के बाद
Please, you see, I am giving you an opportunity.
बोली 3 days टाइम.
Sorry?
कल बोला जा रहा है, हम बोला फिर बोला.
ठीक है, आप बताइए कब चाहिए. 15 तो सैटरडे है, छुट्टी है.
15th is closed. 15th November Monday.
15 तो बंद है. 14 तारीख को रख देते हैं. 14. अच्छा ठीक है. 18 को फाइल करेंगे कि उसके पहले 14 को फाइल कर देंगे.
कमिंग बैक 15 तारीख को.
On 18th you will file it. Post this case on 19th of November 2022 in the supplementary cause list. The affidavit should be filed latest by 18th of November 2024. थोड़ा सा आपको डाउटफुल नहीं लग रहा?
तो interim order को करें.
Interim order passed earlier is directed to continue till 19th of November. Delay we will see. If you have filed the documents, we will take care of it. But you have not filed the, if you have not filed the documents, then you don't have a case.
It is to them to satisfy. The documents are there.
Yes.
They have filed it.
If they have filed it along with it, there is no problem. Photograph, documents, whatever.
Politician attempt to WPC 49.
Documents and photographs. है ना?
Yes.
Yes, petitioner.
Is a challenge in order passed by the Commissioner in purported exercise of powers under Section 28, setting aside the orders passed by the Deputy Commissioner. Now, according to me, this is covered
Section
by
28
of the 1973 Act. We have
shops and establishment.
no. Mutation.
Mutation.
That is covered by your Lordship's one order. Two judgments passed by this court, one by your Lordship's, one by another court. In fact, that Section 28 is not a jurisdictional adjudicatory power.
Yes. So that is the only order on the plan.
Yes.
What is it? Covered.
List of dates
आप covered case में तो कभी नहीं आते. What's there in this case?
and client which list of dates for your Lordship's.
Client तो YouTube में भी देखेगा. आपको क्या?
हाँ वो भूल जाता है बीच में याद नहीं YouTube में. इसीलिए
I have only one submission to make. I will have a liberty to challenge the DC's order.
Yes, that liberty is always there.
हाँ DC's order before the High Court.
Always there. There is no problem.
And if your Lordship permits, then can I?
Yes.
There's one issue which may come up, that prior to passing of this order under Section 28, earlier an order was also passed under Section 28, which was an order of remand. They have taken a plea that you have never challenged that order. There is one judgment of the Supreme Court which says even this is.
You see, they may challenge whatever order they want.
Yes.
Right now, you are concerned only with that.
The subsequent order.
Subsequent.
The first order I did not, but by consent.
And suppose by consent you cannot
I
consider
cannot
jurisdiction, but at the same time, but both the parties have participated.
Correct.
So they can challenge the earlier order also.
That was not necessary because that is no more
That
in
was not
existence.
necessary because that is no longer
No
in
longer in
existence.
existence.
So
That's-
that
I'm just-
estoppel may not.
That is why I
apply.
am only indicating that this is a point which I have raised. Your Lordship, if your Lordship wants to.
आप अपना रेट में दोनों को चैलेंज कर लीजिएगा. पता नहीं, you do not know how will you play
the
the
challenge of DC court. Great.
My lord, I am appearing on behalf of respondent number 9 and 10. Others are not appearing.
Not appearing notices were issued.
Notice-
Sir?
Sir.
Like I also is pending with only technical amendment.
What?
One not.
What technical amendment are you seeking?
That this IA number 6401. This for IA for amendment. And not what is missing in the
Okay, formal. Let us see where is your line. IA number
6401.
क्या करता है ऑफिस? IA number 5633 6401.
6401.
Where is it? आप लोग से अगर काम नहीं निपटता है ना 9 बजे आ जाएगा फर्स्ट कॉपी का
IE is being reflected in the board also.
फ्लैट करके रखना चाहिए ना पहले लिखिए WTC number 4924 of 2019 with IA number 6401 of 2020. Counsel for the petitioner and respondent number
IE respondent number 9 and 10.
9 and 10. And also the counsel for the state. You are for the state?
No.
Are present, nobody appears on behalf of the state. It has been submitted that in spite of service of notice, the other private respondents have not appeared. Counsel for the petition submits that IA number 6401 of 2020 is formal in nature in as much seeking amendment of the petition is formal in nature in as much as there has been certain inadvertent typographical error in paragraph 33, 35 and 36. The counsel for the private respondent does not dispute that those amendments are formal in nature. Considering the submissions, the IA number 6401 of 2020 is allowed. The counsel for the petition is directed to make out necessary insertions / amendment in the main petition in writing to the course of it. The learned counsel for the petition has submitted that the petitioner is confining, the petitioner is aggrieved by the order passed order dated 29/8/2019 passed by the Commissioner Sindhu within bracket Kolhan bracket close division Chaibasa, whereby the learned commissioner has been pleased to restore the order dated 16/1/2012 passed by the circle officer in mutation case number 2284 of 2011-12 And further, क्या किया आपका प्रेयर से पता नहीं चला?
Yes, madam. No pen. Just at least only. May I please?
ऐसे नहीं, just of date से नहीं.
Yes, madam.
The learned counsel for the petitioner has submitted that land under khata number 354, plot number 3772, 3778, 3779, which was recorded in the name of Amar Singh, son of Lal Singh, which name was recorded in the name of Amar Singh, son of Lal Singh, and upon his death, his wife executed a registered power of attorney on 8/1/2007 in favor of Subrato Day. On the basis of registered power of attorney, two registered sale deeds, number 5634 dated 22/8/2009 and sale deed number 7690 dated 16/10/2004 were executed, and thereafter the purchaser, being the petitioner, applied for mutation, which was numbered as mutation case number 886 of 2008. The application for mutation was rejected by the order dated 10/11/2008. Thereafter, an appeal was filed before Land Reform Deputy Collector and numbered as mutation appeal number 14 of 2008-9. The appeal was disposed of and the matter was remitted to the Court of Circle Officer for fresh consideration. On remand, the Circle Officer passed order dated 6/1/2010 and rejected the mutation application on the ground that land pertaining to khata number relates to Adivasi khata. The said order dated 6/1/2010 was challenged by the petitioner in mutation appeal number 37 of 2009-10 in the Court of Land Reform Deputy Collector. The Land Reform Deputy Collector. It has been further stated that the same circle officer on 16/2/2012 allowed the mutation case number 2284 of 2011-12 for plot pertaining to khata number 9 and issued correction slip in favor of Harjeet Singh. You are Harjeet Singh?
No. Vendor actually hasn't transferred the land in favor of the respondent.
The mutation appeal was decided on 29/3/22, whereby the order of the circle officer was set aside and the matter was again remanded for fresh consideration. However, after the mutation was allowed in favor of Harjeet Singh by the order dated 6/2/2012, that this Harjeet Singh's property is a different property or same property? 16/2/2012, he sold the property by sale deed number 7762, 7563, 7564, all dated 13/12/2012, in favor of Sunil Seth, Alok Kumar Jaiswal, and Sunita Seth, respectively. It is further case of the petitioner that the circle officer refused to comply with the order dated 29/3/2012 wherein the Deputy Collector Jamshedpur had directed the circle officer to decide the mutation case 886 of 2008-9 afresh. Consequently, the petitioner filed a writ petition before this court, being WPC number 2223 of 2013, which was dismissed by the order dated 3/12/2013 as withdrawn. Thereafter, the petitioner preferred a civil review, being civil review number 99 of 2013, seeking review of order dated 3/12/2013, passed in WPC number 2223 of 2013. By order dated 29/1/2015, this court was pleased to clarify that the petitioner would be at liberty to challenge the order dated 5/3/2013, passed by the circle officer, by filing appeal under section 15 of the Bihar Tenant Holding within bracket Maintenance of Records bracket close Act 1972. The petitioner filed appeal, the mutation appeal number 8 of 2014-15. ये म्यूटेशन केस का नया केस नंबर
जो रिस्पोंडेंट के नाम पे अलाउ किया
अच्छा 2015 challenging the order dated 16/2/24 passed in mutation case number 2284 of 2019 का केस है 24 का कहानी कहाँ से लेते हैं
सॉरी
this one
सॉरी which date है
this one
सर मैं एक से टाइपोग्राफी करेगा ना सीरियल नंबर 50 मिनट्स में 16/2/2012 it's wrongly mismatched as 16
order dated 16/2/2012
was verified
passed in mutation case number 2284 of 2011-12, which was passed in favor of Harjeet Singh. The mutation appeal was allowed, and the order of the circle officer mutating the property in favor of Harjeet Singh was set aside, and a direction was issued to mutate the name of the petitioner and issue rent receipt. This happened by the order dated 28/8/2015, passed in mutation appeal number 8 of 2014-15. Thereafter, Alok Kumar Jaiswal, Sunil Seth and Sunita Seth preferred mutation revision case number 2 of 2015-16, challenging the order dated 28/8/2015, passed in mutation appeal number 8 of 2014-15. The mutation revision was heard and was dismissed by the Additional District Commissioner East Sindhu, who affirmed the order passed in mutation appeal number 8 of 2014-15. White, order dated 2/3/2017, being agreed with the order dated 2/3/2017, a revenue miscellaneous appeal number 14 of 2017 was filed. And by the order dated 24/1/2018, Commissioner Singhu, in bracket Kolhan, Division Chaibasa, allowed the revenue miscellaneous appeal number 14 of 2017 and remanded the matter to the collector cum deputy commissioner Jamshedpur for fresh hearing. On remand, the deputy commissioner Jamshedpur, by the order dated 14/6/2019, dismissed the revision petition or the
was titled
deputy commissioner, serial number 21. dismiss the revision petition and confirm the order dated 28/8/2015 passed in mutation appeal number 8 of 2014.
Yes, ma'am. Well, in the order it has been titled as revenue miscellaneous appeal. So it was a revision.
ये 21 का सीरियल नंबर
Yes,
में
ma'am.
डिस्क्रिप्शन सही है?
Yes, ma'am. Mutation revision number is page 86.
Yes. On being agreed, Sunil Seth and others referred revenue miscellaneous appeal number 28 of 2019 before the Court of Division Commissioner Singhum within bracket Kolham, Division Chaibasa. And by the ensuing order dated 29/8/2019, the learned Commissioner Singhum within the Kolhan Division Chaibasa has confirmed the order dated 16/1/2012 passed by the circuit officer in mutation case number 2284 of 2011-12 and order dated 5/3/2013 passed by circle officer in miscellaneous case number 2 of 2013 was restored as valid and has been pleased to set aside the order dated 28/8/2015 passed by Land Reform Deputy Collector in mutation appeal number 8 of 2014 and also the order dated 14/6/2019 passed by Deputy Commissioner in mutation revision number 2 of 2015-16. Multiple orders, 2 orders have been set aside by the
Yes.
Commissioner.
One appeal and one second is revision. Which stands here. Yes. Yes.
Miscellaneous appeal number 8 of 2014 has been restored.
No, that was set aside.
That was set aside.
Yes, ma'am.
And what was the other?
Mutation revision number 2 of
Mutation revision number 2 of 2013.
2 of 15/16.
Okay.
Last one.
Mutation revision number 2 of 2015-16. Before the Deputy Commissioner, sometimes it is termed as revision, sometimes it is termed as appeal. Technically, it's an appeal.
No, no. Before LRTC, it must be appeal.
Okay.
Technical. Before DC, it must be a revision.
Revision. There is no question of second revision.
No, that after amendments.
Before the divisional commissioner, it has been titled as miscellaneous appeal.
Okay. The learned counsel for the petitioner has submitted that the petitioner is aggrieved only by the order dated 29/8/2019 and has submitted that in WPC number 4802 of 2019 this court has held that the Division Commissioner Kolhan Division at Chaibasa has no jurisdiction to undertake adjudicatory role by referring to section 28 of the aforesaid Act of 1973. He has submitted that the second revision was not maintainable before the said authority. And therefore the order dated 29/8/2019 is wholly without jurisdiction as the state authority has taken up adjudicatory role and on this short point the ensuing order is executed. The learned counsel appearing on behalf of the respondent number 7 and 8,
9 and 10.
9 and 10 has not disputed the aforesaid proposition in connection with the jurisdiction of the division commissioner, but submits that the right may be reserved with the respondent to take appropriate steps in connection with the various orders by which the private respondents are relieved. He submits that the revision was filed before the Commissioner Singhum Kolhan Division Chaibasa by the private respondent. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances of this case, and after going through the judgment passed by this court in WPC number 4802 of 2019, decided on 9/7/2024, this court is of the considered view that the learned Commissioner Singhum Kolhan Division Chaibasa had no adjudicatory role, and therefore the revision filed before the respondents, before the private respondents, before the learned commission, by the private respondents before the learned Commissioner Singhum Kolhan Division Chaibasa was itself not maintainable. Consequently, on this short point, the impugned order dated 29/8/2019 is hereby set aside. However, it is certainly open to the private respondents to take steps in connection with the orders which has been set aside by the impugned order. Right?
One submission. If not the order is set aside, we just authorize you directly to act.
Sorry, what is? We will not say anything. बहुत ज़्यादा कहानी है आपके पास. Lot many stories. इसको आप करेक्शन कर दीजिए.
Yes, ma'am.
For hearing item 4, WPL 1771 of 2009.
Yes, petitioner.
Ladies, I'm praying for a short fast. My senior is supposed to assist.
Yes, yes, yes.
Mr. Amit Kumar. He's on legs in court number 3. He was here. He'll just be.
Records have come. Records आया.
This case is coming after long time. We have not been reporting.
Record नहीं है. The matter is only relating to break, artificial break.
Artificial break in service.
That is all.
And the London Labour Court has given a wrong finding on the continuous date of service which I have rendered in the past 1 year. They have given that I have rendered only 115 days, but as per my WS filed in the lower court, I have worked for 237 days, and the respondents have arbitrarily given me a break in service so that my 240 days are not concluded in a year.
That is artificial break. This is covered by a judgment of Supreme Court.
Yes, Lord.
That this artificial break cannot, they are not actually break in service.
There is one judgment of page number 108. I'm giving all the details of the days I have worked. 1110 is the relevant part.
He is seeking adjournment in council. Do we need the records or we don't need the records? After hearing, I will not adjourn it for the records.
Courts may be called.
The learned counsel for the parties are present. The learned counsel for the parties submit that the records be called for from the concerned court. Office is directed to call for the records in connection with reference case number 12 of 2003, decided on 8/2/2008 by the learned presiding officer, Labour Court of Jharkhand. Let this order be communicated through fax. Post this case under the heading for final disposal on 19th November. ठीक है? इलेक्शन तो 20 तारीख को है ना?
Yes.
23rd.
23rd को काउंटिंग
काउंटिंग है. 19th को क्या है?
13 and 20 को
Item 5, WPL 1798 of 2009.
Petitioner. Where is the petitioner? Mr. Nipun Bakshi. For the petitioner, yes. What is it? टाइम से ला कोई बात नहीं लोअर कोर्ट अब पढ़ना शुरू पढ़ नहीं पाए नहीं पढ़ पाए रात को लिस्ट नहीं मिला क्या
एक रिटन नोट बनाना है इसमें पड़ेगा.
रिटन नोट बना हुआ It's there.
That one I would be present.
Sorry?
One is to present.
You are for the Workmen?
Yes, I am for the work.
You have been acquitted in the criminal case.
Yes.
इसीलिए आप केस फाइल किए. इसमें क्या आपको चाहिए? बताइए. कल कर दीजिए.
Tuesday.
Who is for the private respondent? Respondent for this. Huh?
BCCL.
BCCL. उनको बुलाइए. उनको बता देंगे.
बता दीजिए टाइम.
तो बता दिए थे कि टाइम लेंगे. Very good. उनका absence record कर दीजिए. The learned counsel for the petitioner is present. The records have already been received from the concerned court. The counsel for the petitioner seeks adjournment to prepare himself in the case. Nobody appears on behalf of the respondent. The learned counsel submits that Mr. Anup Kumar Mehta appears for BCCL in this case, and he has already informed him that he will be seeking time. He submits that the matter be posted on next Tuesday. आज Wednesday? Thursday.
22nd.
He submits that matter be posted on 22nd, Thursday.
22nd is Tuesday.
Also, on 22nd of October 2024, under the heading for final disposal, and he shall not see any adjournment on that day. He has also undertaken that he shall inform Mr. A.K. Mehta about the next date. Adjournment के लिए inform किए थे इसके लिए. Post this case for final disposal on 22nd. एक 12 बजे लिखाना है.
This is from supplementary list. Item 5, WPS 452 of 2006.
In fact, no votes. Okay, WPL number 452 of 2006. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner, by giving the background of the case, has submitted that the father of the petitioner was an employee of the father of the respondent. The father of the respondent was an employee of the petitioner.
Respondent to the union. Respondent to the union. JP Singhania was the.
Oh, yes. The learned counsel for the petitioner submits that one JP Singhania was the employee of the petitioner and he had challenged his order of dismissal dated 3/8/1982 in reference case number 310 of 1986, which was decided in his favor on 27th of February 1992. However, the learned tribunal, while deciding the reference, recorded also during the pendency of the reference, J.P. Singhania, hereinafter referred to as the Workman, J.P. Singhania expired and he was substituted by his wife, and
Date of death is 13/4/1990. That is
13/4/1990.
1990.
Died on 13/4/1990. He submits that the tribunal, while setting aside the order of dismissal and answering the reference in favor of the Workman, granted full back wages. And since the Workman had already expired, it was observed that the management may take a compassionate view of the matter and give employment to his dependent son as per rules and procedure. It was also directed that the management will pay all the back wages and other consequential benefits to the widow of the Workman from the date of his dismissal till the date of expiry of 1 month from the date of publication of the law. तो मरने के बाद का भी अमाउंट था? मरने के बाद का भी अमाउंट था?
नहीं, मरने के बाद का अमाउंट टिल
Till his death.
उसके पहले में मेंशन करना चाहेंगे ये कहता है फॉर द चार्जेस ऑफ embezzlement and FIR was lodged and he was
उतना लिखने का जरूरत नहीं है ना?
जी
इतना लिखने का जरूरत नहीं
जी।
है. What was the charges? He has been exonerated, madam.
जी
The learned counsel submits that the direction in connection with compassionate appointment to the dependent was beyond the terms of reference, and accordingly the petitioner wanted to challenge the award. However, the wife of ex-employee and her two sons approached the petitioner, and ultimately settlement was arrived at on 28th of February 1996. Which was duly signed by the wife of the ex-employee and two sons. And as per the settlement, the management was not to file any writ petition challenging the award, and it was also observed in the settlement that the two sons of ex-employee were duly engaged in domestic business and they are not interested in getting employment from the company. It was also agreed that the entire dues as per the award would be paid to the wife of the ex-employee. The learned counsel submits that as a consequence of the said settlement, the petitioner did not challenge the award and the entire dues were paid to the wife of the ex-employee. He submits that after taking advantage of the settlement, one of the son of the ex-employee, namely Anand Kumar Singhania, raised an industrial dispute through another union. Yes, through another union, and ultimately the matter was referred for adjudication by the tribunal, which was numbered as reference case number 125 of 1996. The learned counsel submits that Anand Kumar Singhania filed his written statement but did not disclose about the aforesaid settlement, and the management in the written statement had specifically raised the matter regarding settlement out of court, regarding the settlement, and the settlement was also brought on record before the learned tribunal, and he submits that Anand Kumar Singhania admitted the existence of the settlement and also exhibited the signatures of the three persons as of his family as exhibit N/1, M-1/1 and M-1/2. He submits that the learned tribunal recorded that no reason was assigned on the part of the sponsoring union for concealment of the existence of the settlement in the written statement, and in spite of having recorded so, the learned tribunal referred to section 19 and rule 58 within bracket 4 of the Industrial Disputes Act and held that the same cannot be said to be a settlement in the eyes of law, and ultimately held that so long as the award of industrial tribunal does not terminate or is not terminated in accordance with section 19 of the Act, there cannot be a settlement between the employer and the employee with regard to the matters covered by the award. The learned counsel submits that after having held that the same was not a settlement in the eyes of law, and has settlement in the eyes of law, directed the petitioner to act in terms of the award in passed in earlier reference case number 310 of 1968. 1986 86 है ना 310 of 19 उसमें दो लिखा हुआ है 68 भी लिखा हुआ है 86 भी 1986. The learned counsel, while assailing the improved award, has submitted that the said settlement cannot be termed as a settlement in terms of Industrial Disputes Act, as it was not entered into between the employee and employer. He has referred to the definition of settlement and also the definition of employee. He submits that the same was at best an agreement, and the parties having acted in terms of the agreement cannot rescind from the agreement. He submits that in such circumstances, reference to the provision of section 19 and rule 58 within bracket 4 of the Industrial Disputes Act was completely misplaced, and therefore the improved award calls for interference on account of such perversity.
Second reference was not maintainable.
He has also submitted that second reference itself was not maintainable, as there was already an award for regarding consideration of dependent employment to the son of the ex-employee.
no execution was filed under section 11(9).
He has submitted that in view of the out of court settlement, the son of the ex-employee, namely Anand Kumar Singhania, did not file any execution case before the court, and instead raised an industrial dispute by suppressing the factum of out of court settlement. Anything else you want to say?
The employee, your lordship, died on 13/4/1990,
Yes.
and therefore on the date of death he was not on the roll. Therefore a death employee cannot, this dependence of a death employee cannot.
The Learned Counsel has also submitted that the ex-employee expired on 13/4/1990, and on that day the ex-employee was not on roll, and therefore a dependent of a dead person who was not on roll cannot claim compassionate appointment. What else?
Further, this is a belated claim after 34 years now. No such compassionate appointment since he has survived for such a long time.
The Learned Counsel has also submitted that as on today, 34 years have elapsed, and therefore the impugned award is not capable of compliance.
Further, the sons of these J.P. Singhania has exceeded now the age of 35.
And the Anand Kumar Singhania must have exceeded the age of superannuation by now.
35 years.
35 years has elapsed from the date of death of this court. Any stay order passed by this court? Any stay order passed by this court?
Stay order.
He has submitted that by the order dated 24/2006, the impugned award dated 20th April 2005 was passed in reference case number 125 of 1996 was stayed. That's all. ये subsequent जो submission है इसके बारे में क्या बोलना है? 35 years. What do you have to say?
My information, my lord, he has not attained the age of superannuation. Of
Of
course,
course,
my
we
lord, 58.
हमारा सबमिशन है कि 35 इयर्स को एक्सीड कर गए हैं, एज पर द एनसीडब्ल्यू 35 इयर्स जो एक्सीड कर जाते हैं उनको नौकरी नहीं दी।
Okay, इसको ठीक समझिए. The Learned Counsel for the petitioner has submitted that as per National Core Wage Agreement, any person who exceeds the age of 35 years is not entitled for compassionate appointment, and therefore the relief as granted by the tribunal cannot be granted to Anand Kumar Singh. अब तो आपको कुछ नहीं बोलना. The Learned Counsel appearing on behalf of the, you are representing union or the Workmen?
My lord, union is representing the
On behalf of the respondent union, by opposing the prayer, has submitted that the scope of has submitted that the reference was never challenged by the petitioner. Once the reference is made, the same is required to be answered by the industry and it has been accordingly answered. The Learned Council has further submitted that there was a fresh cause of action inasmuch as pursuant to the award, an application was made for consideration of compassionate appointment, and when no order was passed, the Anand Kumar Singhania raised industrial dispute. He has further submitted that since the parties are governed by National Coal Wage Agreement, therefore the persons claiming to be the legal heirs of ex-employee and entitled to one or other benefit under National Coal Wage Agreement are entitled to raise industrial dispute, and therefore the industrial dispute was rightly raised. He has also submitted that no objection in connection with the raising of industrial dispute was made by the petitioner before the learned labour court, before the learned tribunal, and their only point was referable to the so-called settlement, which the learned tribunal has considered and has observed that the settlement was not in accordance with law and therefore not binding. He has also submitted that the petitioner claimed to the settlement to be settlement in terms of the Industrial Disputes Act before the learned tribunal, but before this court he is taking a different stand and is trying to save the settlement by stating that it is an agreement and not a settlement in terms of the Industrial Disputes Act. The Learned Council submits that merely because the Anand Prakash Prasad Singhania might have attained more than 35 years of age, the same will not be an impediment in the matter of grant of employment, as he cannot be made to suffer on account of any interim orders passed by this court. The interim orders are required to be taken to a logical end while passing the final order. That is all. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that one reference case number 310 of 1986 was instituted to decide the following reference. Annexure 1 में the schedule following terms of reference. However, the ex-employee, namely J.P. Singhania, expired in the year 1990 and his wife was substituted. The learned tribunal, while passing the award, granted the following relief, paragraph number 12. This court further finds that there was a direction, the learned tribunal, by deciding the reference on 27/2/1992, observed that the management may take compassionate view of the matter and give employment to the dependent son as per rules and procedure. It further appears that the Workman, it further appears that the management and the legal heirs of it further appears that a so-called settlement was entered into between the petitioner and the legal heirs of J.P. Singhania, and the management agreed to give all the benefits arising out of the award to the wife of J.P. Singhania, and it was recorded that the sons are engaged in domestic business and they are not interested in any kind of employment. It further appears that the payment was already made. It was also observed that the management would not file the writ petition challenging the award. It further appears that the management ultimately did not challenge the award, and in the meantime, one of the sons of the ex-employee, namely J. Anand Kumar Singhania, raised an industrial dispute which was referred for adjudication. The terms of reference are as follows. The industrial dispute was apparently for the purposes of implementation of the award passed in reference case number 310 of 1986, with a further development that in spite of having approached the management for compassionate appointment in terms of reference case number 310 of 1986, the management did not grant employment, did not consider the plea of compassionate appointment of Anand Kumar Singh. This court finds that the union representing the workmen in their written statement did not disclose about the so-called settlement, and this factum was brought on record by the management. And the learned court, by considering the settlement, has considered the evidence of the workman and has observed that the workman admitted during evidence that there was existence of settlement which was duly signed, but no reason was assigned on the part of the sponsoring union about the reason of concealment of the existence of that settlement. This court has gone through the evidence of Anand Kumar Singhania, who was examined as WW1. Wherein he has stated that in the earlier award, there was a direction to the management to provide employment, but the management did not carry out the order. However, the management paid back wages to his mother, and at the time of payment, obtained his signature on a paper wherein it was declared that he should not be claiming employment. He also exhibited 3 affidavits in original sworn by him, his mother and brother, which were marked exhibit W2, and stated that his brother was dead. This court finds that the learned tribunal, while considering the settlement, was of the view that the said settlement was not in consonance with the provisions of Section 19 and Rule 58 within bracket 4 of the Industrial Disputes Act 1947. Though it was the specific case of the management before the learned tribunal that the award was replaced by the settlement dated 28/2/1996, and the award got automatically terminated as per the provisions of Section 19 of the Industrial Disputes Act. It was also their case that the award remained valid for a period of 1 year and continued to remain valid till the same was replaced by another award or settlement, and that the award may be terminated after expiry of 1 year in accordance with the provisions of Section 19 of the Industrial Disputes Act 1997. This court finds that the management, having taken a specific stand before the learned tribunal that the settlement was in terms of the provisions of Section 19, that the award was terminated in terms of the provisions of Section 19 of Industrial Disputes Act 1947. The learned court examined this aspect of the matter and held that the settlement was not in terms of Section 19 and Rule 58 within bracket 4 of the Industrial Disputes Act. During the course of hearing, the learned counsel for the petitioner has not disputed this finding. Rather, a new case has been sought to be made out that the settlement itself was not a settlement but was an agreement, as the same was not entered into between Workman and management, by stating that Anand Kumar Singhania was not the Workman, and therefore the agreement cannot be termed as a settlement. This court is of the considered view that a new case has been sought to be made out by the petitioner before this court, challenging the award under Article 226 of the Constitution of India. Such a course of action or argument on behalf of the petitioner is not permissible in the eye of law. This court also finds that the petitioner has also raised a plea that this court also finds that admittedly the parties are governed by National Coal Wage Agreement, in which certain benefits are conferred on dependents of ex-employee, and therefore it cannot be said that the reference itself was not maintainable. This court also finds that the reference was never challenged by the petitioner, and the petitioner fully participated in the reference, did not raise any point of jurisdiction so far as the maintainability of the reference is concerned, and such point is being raised for the first time before this court, which is also not permissible in the eyes of law. So far as the argument of the petitioner that second reference is not maintainable, this court finds that such point was also not raised. This court finds that after the award passed in reference case number 310 of 1986, there was subsequent development in as much as Anand Kumar Singhania claimed to have approached the management for grant of compassionate appointment, but the management did not consider his claim. This court is also of the considered view that the award dated 27/2/1992 did not terminate as per the provision of law, and therefore cannot be said to have been replaced by the so-called settlement. So far as the argument of the petitioner that Anand Prakash Singhania has by now crossed the age of 35 years is concerned, this court is of the view that the award was passed way back on 20th of April 2005, and the operation of the award was stayed by this court in such circumstances by efflux of time. If Anand Prakash Kumar Singhania has attained the age of 35 years, the same by itself cannot be a ground to deny the fruits of the award dated 20th of April 2005. This court further finds that by virtue of the impugned award, the learned tribunal has only directed the petitioner to act in terms of the award passed in reference case number 310 of 1986, and there is no direction as such to grant compassionate appointment. It is certainly open to the petitioner to
So what may consider?
And in the award passed in the earlier reference, there was a direction that the management may take a compassionate view and give employment to the dependent son as per rules and procedure. Certainly, the parties are governed by rules and procedure. It is all. So far as the argument of the petitioner that the ex-employee expired in the year 1990 and he was not on roll is concerned, this court finds that the ex-employee was not on roll on account of order of dismissal, and the order of dismissal was set aside by the learned tribunal in the earlier reference with all consequential benefits, and therefore such plea of the petitioner cannot be a ground to set aside the impugned award. That is all. Considering the totality of facts and circumstances, this court finds no merit in this writ petition, which is hereby dismissed. Let the records be remitted back to the concerned.
From credit list item 6, WPL 2858 of 2009.
What is the case?
The award is under challenge at page 48,
Yes.
section 9.
Yes.
Reference was whether the action of the management of Jharkhand Colliery of CCI, PO district Hazaribagh by not regularizing and not making payment of difference of wages of Sri Shamlal Murmu to Shamlal Kurmi, Jawahar Singh Muhammad and
Yes, his names पढ़ी का जरूरत आगे बढ़ो।
is justified. If not, to what relief the workman person are entitled. So for this repetition is against the award, only against workman Shamlal Kurmi.
Shamlal Kurmi.
Shamlal Kurmi. Case of the workman is that he was appointed sometimes in the year 73 as peace rated worker, and
What is so specific about Shyamlal Kurmi that you have not challenged against others?
against other the award was not passed. Only
It was
award
not
is
passed against others. Only in favor of Shyamlal Kurmi.
Yes.
So the claim of rest of the persons was rejected.
Denied.
So what is the specific discussion with this respondent, Shyamlal Kurmi? Discussion बताइए कहाँ पर है?
Para 5
पढ़ी पैरा 5 पढ़ी
page number 6.
पढ़ी
6. As per paper filed by the workman exhibit 2, Shamlal Kurmi has been given training of lathe machine from 16/11/1988
19
88 to 16/3/89
16/189
16/189
for 2 months.
for 2 months. And as per exhibit W1, he has been given order for training of lathe machine as per exhibit 3 W3. He is authorized by the project engineer by office order number such and such dated 26/12/94 to work on lathe machine as and when required, and as per exhibit W4, he was authorized to work as EP turner for 15 days, and as per exhibit 5, he has been authorized to work as EP turner. As per exhibit 6, full charge has been given for repair.
Full Muhammad has been given.
Oh, sorry.
Full Muhammad has been given for repair and maintenance of
Maintenance of
engine sections.
Full Muhammad is another person.
Full
Full Muhammad is another person, Lord. Yeah, Full
He
Muhammad
was
is another
divided
Christ.
into
ठीक है इनका
But
तो
he was not
that's right.
trainer.
That's right. As per late, so it is still this exhibit W5 is still for this Workman.
As a EP turner,
EP turner.
EP
वहाँ तक
turner.
का सारा document is with respect to the respondent.
Lord.
Yes.
Exhibit W7 has been addressed to project engineer management document.
Yes. What is the perversity in the order?
Perversity in the order is writ large of the face of record manner, since this workman was undergone training in the year 1989 and got the training of Turner, and he was given wages from 1982. it is their case that he got training in the year.
He was given training, but he was working since 1982.
Yes. So without training, no one can.
No, who says without training nobody can be inducted?
It is
We
specialized.
do not know. We do not know that you cannot induct anybody without training. Show us some room in the award.
So this is the only point we have taken, my lord. But para 8 may be looked into. In the facts and circumstances stated above, the award is made. The action of the management of Jharkhand Colliery of CCI is not regularizing and not making payment of difference of wages of Shyamlal Kurmi is not justified. Accordingly, the concerned workman Shyamlal Kurmi is entitled to be regularized as category 6 with effect from 1/1/82, and the difference of wages between category 5 and category 1 with effect from 1/1/82 and difference
Para number 8.
para 8 last para, page 5, page 7 of the
हाँ ऐसे क्या पढ़ेगा? Yes. Is entitled to
Yes,
regularization
absolutely.
as per
Entitled to
category 4 with effect
regularizations.
from such and such date. इतना नहीं हो सकता. Writ में इतना नहीं हो सकता. That's all.
तो 1/1/82 क्या कोई क्राइटेरिया नहीं है 1/1/82.
He was engaged from 1/1/1982. That
No,
was
he
a
was-
specific case.
He was engaged since 1973.
That's right.
What is his statement? That is at page 45 of the brief. Initially, I was appointed as peace-rated worker in the Jharkhand Colliery sometimes in the year 1973. Thereafter, from the year 1982, I was being assigned the work of mechanist, come fitter, come turner
Yes.
at
He has said that he has been working in that post since 1982. That was his specific case.
So when he was allowed to take training of the turner in the year 1981, and without training, no person can be allowed to operate the machine. How he is saying, it is where he is saying, and the document which he has exhibited, that is exhibit number 1, annexure number 1, office order dated 12/6/94, Sri Shyamlal Kurmi, Miss Mazdoor category 2 is hereby authorized to work on lathe machine as and when required. This issues with the approval of the competent authority. It is page 20 of the brief. It is exhibit W3.
only after getting training the workman can be allowed to work on lathe machine. And he was allowed to work after taking approval of competent authority. Then another office order dated 28/1/19.
So those things we are not doing. You have to show us the perversity.
So the document which they
It is not a case of no evidence.
no,
Is it a
is
case of no evidence? No.
it is case of non consideration of the document. The document says otherwise than the award is. Page 21 says office order Sri Shyamlal Mogu category 2 Mazdoor is hereby authorized to work as EP turner as and when required. This is as per approval of the competent authority. So without taking approval from the competent authority, the workman cannot be allowed to work in lathe machine, and there is no other document with the workman to show that he was allowed to work in the lathe machine without the approval or order of any authority. He himself is saying that in the year 1989 he got the training. Annexure 2 is the certificate issued by the authority. It is his document which was exhibited there as Exhibit W2. Sri Shyamlal Kurmi, having completed the course of on-job training in.
You read para 6. Ready?
The management fitness NW1 admitted that the workmen were working as helper in excavation section and initial appointment is made there on category 1 and category 2 and therefore
Thereafter,
It starts from category D.
so date is not there. They are allowed to work. It is not our admission that since 1982 they were allowed.
Seven.
As per WW1, Shyamlal Kurmi, it has stated in cross-examination that Kul Muhammad has not got training. It shows that Kul Muhammad has been promoted from category 1 to category 2, and in this respect he is not entitled for any promotion in grade D or E. But as regards Shyamlal Kurmi, he has been given training and also worked as
According to you, since when he was working as a turner? You tell us the date.
only after getting training.
When? From where are you saying this? From where? The management must have stated so in their written statement that only after getting training he was engaged as that. Show me that statement in your written statement. that prior to this date, before obtaining training, he never worked as a turner or he never worked as the category in which he is claiming.
I may be allowed to read para from para 6 of the written statement. It is page 34. That says Shyamlal Kurmi was previously a peace-rated worker, and on his request he was assigned to do the work of a Mazdoor in category 1, and later he was placed in the post of miscellaneous Mazdoor in category 2 with effect from 8/9/90. And he has been performing a job of miscellaneous Mazdoor, and he is attached to the turner. There is only one lathe machine in the workshop, and there are 2 turners already working in the workshop. There is no requirement for any more turners.
Yes,
The-
respondent,
Lord
show us
Sabha-
any finding from the award that he has been working as a turner since 1982. Show me that finding and I will dismiss his case right now. Only finding. I want a finding in the award because the relief has been given since 1982.
Yes.
Show me that finding that he has been working since 1982 as a turner, irrespective of training. Finding दिखाइए.
Lordship, para 2 of the
Para 2 is the case. Finding change.
finding.
I need a
Lordship,
finding.
Finding Lordship in the fact circumstantial Lordship.
ऐसा नहीं होता ना. The court has to give a finding that he was working as a turner since 1982. Show me that finding. Where is that finding? ये 1982 का जो डेट है, ये अचानक फाइंडिंग में कहाँ से आया? There has to be a finding because you claimed that you were working as a trainer or turner. I don't know, turner since
Turner.
1982.
Yes.
That was your specific case.
Yes.
Where is that
Lordship,
finding?
Lordship, I want to in counter affidavit, Lordship. I want
Counter
to.
finding. Award से दिखाइए. Award से दिखाइए finding.
Para 5 to such person. As per paper filed by Workman Exhibit W2 Shyamlal Kurmi given training of lathe machine from 19 and for 2 months as per exhibit has been given order for training of lathe machine as per exhibit. He is authorized by the project engineer by office order dated such and such dated 34 to work on lathe machine and when required and when if he was authorized to work as a EP turner for 15 days and authorized to work EP turner. So the lathe machine, these documents show the management has taken the work from Shyamlal Kurmi as mechanic, filter and turner. The management's witness.
With effect from which date?
Shyamlal Kurmi and machine grade. Para 7 as per the This category is not determined to number of persons as per unit 1 cell we have promoted to group D at cell number 52. Full chance has been recognized in category 2 to eligible to several people has been formatted and also but as per document filed by the organization so that the performing the job mechanical fitter turner work has not been promoted and given this category and will be recognized as category 6 defect 1182 and difference is 1182 and between categories and category para 6 to recognized as category 6 with effect 1982 and difference of wages between category 5 and category with effect 1982 and between difference of wages between category 5 and category 1 with effect 1989 as regards full Chandra is not entitled any relief according to the management director improvement award number.
Heard the learning council for the parties.
So there is no finding.
This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the award was passed in relation to as many as 6 workmen, but the petitioner is aggrieved only in connection with the matter regarding Shyam Lal Kurmi. He submits that as the improved award has been passed in favor of Shyam Lal Kurmi, and so far as the others are concerned, they have not been given relief by the learned Labour Court, Jamshedpur.
Dhanbad.
Learned Industrial Tribunal.
Central Government Industrial Tribunal number.
The learned counsel submits that the concerned workman, namely Shyamlal Kurmi, had received training on lathe machine only from 6/11/1980 to 6/1/1989 and
82.
16/11/1988 to 16/1/1989 for 2 months, and thereafter, having trained, he worked on lathe machine. And therefore, and there is no finding that he has worked on lathe machine with effect from 1/1/1982, and consequently the award passed by the learned Industrial Tribunal giving relief of regularization in category 4 with effect from 1/1/1982 and all consequential relief flowing therefrom is perverse and calls for interference. यही है आपका केस. The learned counsel appearing on behalf of the respondent while opposing the prayer has submitted that the scope of interference in award under Article 226 of the Constitution of India is very limited. There is no perversity in the impugned order. He has further submitted that a specific finding has been recorded by the learned tribunal after considering the materials on record that the management has been taking work from Shyamlal Kurmi as mechanic, computer and turner, and as per the documents filed by the Workman, it showed that Shyamlal Kurmi was performing the job of mechanic, computer and turner, but was not promoted and given his category as per rules. The learned counsel has also submitted that the learned Industrial Tribunal has also recorded that one full Muhammad who had not got training was also promoted from category 1 to category 2. Was promoted from category 1 from category 2. He has submitted that in view of the findings recorded by the learned tribunal that Shyamlal Kurmi was entitled for promotion but was not given promotion as per rules. The impugned award does not call for any interference. He submits that it was the specific case of the workman that he was working in the colliery as fitter from 1982, and therefore he was entitled for the appropriate times.
Lordship is disregarded as one judgment, Lordship. The petitioner, in this case, the petitioner is obviously charge of post of chief engineer, and but in 2001, on which he continued and promoted on that post 2005. He is entitled to get the salary of the post of the. This is the.
The learned counsel submits that the petitioner, having taken the work from the workman as fitter from 1982, were not justified in were required to give promotion to him as per rules, and in view of the finding that he was not promoted and given the category as per rules, the impugned award does not call for any interference. That's all.
This is the judgment, Lordship, very concerned.
The learned counsel has also submitted that has also relied upon judgment passed by this court.
By this court.
By this court in
JLJR. Lordship, maybe.
Reported in
JLJR.
2013 within bracket 4 JLJR.
Page number 308.
Page number 308 within bracket Kedarnath versus State of Jharkhand, and I submitted that this court has taken a view that if a person is working on a particular post without getting promotion, he is entitled to wages. इसको क्यों साइड कर रहे हैं? झारखंड सर्विस कोड का कहानी तो भी कहीं साइड कर कोई जरूरत नहीं इसका हटा दीजिए एकदम एब्सोल्युटली अननेसेसरी है. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it was the specific case of the petitioner of the workman, namely Shyamlal Kurmi, that he was working as fitter from 1982. But was getting only category 1 wages. The learned tribunal has considered the numerous documentary evidences filed by the parties and has recorded on the basis of documents and has recorded that the document showed that the management had taken the work from Shyamlal Kurmi as mechanic, computer and turner, and as further recorded in paragraph 7 of the impugned award, that as per the documents filed by the workman issued by the management, it showed that Shyamlal Kurmi was performing the job of mechanic, fitter and turner work, but was not promoted and given his category as per rules. Having recorded the aforesaid finding, the learned tribunal passed the following award, para 8. Considering the finding recorded by the learned tribunal that Shyamlal Kurmi was performing the job of mechanic, fitter and turner work and was not promoted and given his category as per rules. This court finds no reason to interfere with the impugned award under Article 226 of the Constitution of India. Accordingly, this petition is hereby dismissed. So far as the argument of the petitioner that that no specific finding with regard to the fact that he was working as turner since 1982 is concerned, this court finds that the same by itself is not sufficient to interfere with the impugned award, as the learned tribunal has already recorded that the concerned workman was working as turner, fitter, but was neither given his appropriate category nor was given promotion as per applicable rules. No such rule has been exhibited by the management before the court that in absence of training, the concerned workman would not have been engaged as turner, fitter